All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you and welcome back, everyone. I understand that may be a need to update the record of appearances so we note whether somebody's been absent or new people joined us. No?
Thank you, Your Honor.
Thank you.
Mr. Amr Hadid is back with us in the delegation.
Thank you very much, Ambassador. Yes, please.
Thank you, Honor. Mr. Sean Yao joined us as well. Thank you.
Thank you, Ambassador. All right, let's then continue with the submissions then. I think it's the turn of Ms. Robinson now. Yes, please.
Thank you, Your Honors. I know it's been a long week and you've been doing a lot of listening, so I will make things easier on you in two ways. Number one, I expect that I only need 15 minutes. I can take 12 minutes on points where I think I have something particular to help you on key points that have been raised in just the last couple days. And then I'll take 3 minutes outlining these ideas that my group of scholars had for finding middle ground. To make it also easy, I will just tell you right up front what I think are the 3 most important points that I'm going to make. The first is I think the appeals chamber should address and rebut the recurring argument that this interpretation by the pretrial chamber, quote, turns Sudan into a state party. I think it's important to address that. Sudan's not a party, but the council has imposed obligations of cooperation under Chapter 7, which are delineated by the Rome Statute. And the obligations the council has imposed are less burdensome than the obligations that were imposed when it created the Yugoslav and Rwanda tribunals. Second, the UN Security Council has previously removed immunities, and the formula it used to do that was cooperate fully. It's the identical technique they used here, cooperate fully with an instrument that removes immunities. And the third point I'm going to make is about ordinary language. The phrase cooperate fully has to mean all the cooperation obligations in the statute. Because if it doesn't, then it's cooperate less than fully. And I think just that cooperate less than fully is not a reasonable interpretation of cooperate fully. I should also say at the outset that my group of scholars, we agree with Roger O'Keefe that the mere referral probably does not move immunities. In our view, it's the obligation to cooperate fully that does the work. But jumping straight to the interesting bits. So one of the interesting questions, can the council impose obligations that are the same as those found in treaties? The answer, I think, is clearly yes. There is no exception in Chapter 7 saying that the council cannot impose obligations if they are also found in a treaty. And the council has already done so with counterterrorism, nuclear test ban, nuclear non-proliferation. Even more saliently, the council routinely orders cooperation with other international bodies, including bodies created by treaties. World Health Organization, African Union, OPCW. It's been suggested that's extraordinary. I don't think it is. I think it's routine. And doing so does not violate the law of treaties. The council is imposing obligations under the UN Charter pursuant to the law of treaties. So that brings me to this first key point that we suggest that the appeals chamber in its decision should address this argument because it is a source of confusion. That the Security Council can't turn a state into a party, a quasi-party, a fictitious party, and so on. It's important to explain that it's not what's happening. The council is imposing an obligation under Chapter 7. The council delineates the scope of the obligation that it imposes by reference to the Rome Statute. So the source of the obligation is the Charter. The content is delineated by the statute. Now, earlier today, Roger O'Keefe said that it takes calisthenics to think that the Security Council meant to delineate the obligations by the statute. I think the opposite. I think it takes calisthenics to think that they didn't mean to refer to the statute. Otherwise, what does cooperate fully mean? Is Sudan supposed to provide tea and biscuits if the prosecutor arrives? There's only two possible ways to interpret cooperate fully. Either we take it literally, and it means do everything the ICC asks. That's the literal interpretation. Alternatively, we give Sudan the benefit of all the exceptions and limitations enjoyed by states parties, which I think it's the second one. But the Rome Statute is the obvious circumscription of the scope of the obligation, and the Security Council referred to the Rome Statute 4 times in the preamble. Now, importantly, Sudan's obligations differ from a states party in 2 ways. And I think this is important to clarify because there's been expressions of confusion about what is Sudan's obligation. First of all, the Council has only imposed the cooperation obligations. So the Rome Statute also contains governance obligations, paying assessed contributions, rules on how do you elect judges, and so on. Those are not imposed. It's just the ones about facilitating the investigation or prosecution of a case. But the second important limit is the Council only imposed obligations in relation to the Darfur situation, whereas states parties have to cooperate in relation to all situations. And the Council imposed this narrowish obligation in response to a threat to international peace and security, namely the killing of 300,000 human beings. And this obligation, it's less burdensome than what the Council imposed. When the Council imposed the Yugoslav and Rwanda tribunals on states parties, it imposed a series of open-ended obligations that were left for the tribunals to interpret. By contrast with the ICC, it's really quite regulated and spelled out in advance. Now, people argue if the Council affects immunity, it needs to be express. I think the Chamber's decision should say, since when? Since when is this a rule? The Security Council, when it created the Yugoslav and Rwanda tribunals, it removed immunities, and it did so without saying the word immunity. So there is no such requirement. It's directly contradictory to the UN Security Council's practice. Moreover, the Security Council routinely makes decisions that have massive implications with very few words. It's a famously succinct, famously terse body, the Security Council, which brings me to my second key point. And Helen Brady touched on this yesterday, and I was glad to hear it because I don't think it's made enough. This formula, cooperate fully, which we're told is not clear enough to remove immunities, is the identical formula that the Council used when it created the Yugoslav and Rwanda tribunals. Everyone seems to agree that removed immunity. And what it did is it ordered full cooperation with an instrument that removes immunities. Now, I've seen some efforts by people to argue that those words, for some reason, worked for the tribunals, but somehow don't work for the ICC. And I think the distinctions are strange. One distinction I've read was it worked for the tribunals because the Security Council appended the statute to the resolution. Another one I've heard is it worked because the tribunals are a Security Council creation. Those are seizing on details that have nothing to do with the legal technique. The legal technique was Council, under Chapter 7, orders full cooperation with an instrument that removes immunities of the states bound to it. It's the same technique. Another argument that I've seen is that it worked for the tribunals, but not the ICC, because for the tribunals, the obligation was imposed on all UN member states. But I think that's irrelevant. In this case, we have a trilateral relationship: the ICC, Sudan, and Jordan. Sudan and Jordan are both bound to cooperate fully. The situation of every other state is irrelevant to the analysis. In any case, the Council here was express. They expressly said cooperate fully. So the only job you have, is to identify that's a package of obligations. You have to interpret what does it mean, and the package is going to be interpreted by reference to the ICC statute. So what does this phrase mean, cooperate fully in the resolution? By the way, I think that when you interpret cooperate fully for this case, you will also be saying, what does it mean for states that make an Article 12.3 declaration? Because it's the same phrase. I think it's going to have the same meaning. Now, some say that that obligation only imposes the obligations in Part 9 of the statute. And I suggest to you that's really untenable, because there are cooperation obligations sprinkled throughout the statute. Now, in our brief, we just put a footnote listing examples, but let me actually expand more than we did there and just give you some examples. Article 48, a state has to respect the immunities of ICC officials visiting the state. Article 58, you have to transmit a summons to appear if the ICC asks. Article 72 and 73, you have to hand over national security information with various safeguards. Article 75, help us out with reparation orders. None of those obligations appear in Part 9, they're throughout the statute. But to exclude those cooperation obligations, just because they're not in Part 9, would mean cooperate less than fully. And I think this is my third key point. I think the appeals chamber, in its judgment, should emphasize ordinary language. I think you should cite a dictionary. I looked in the Oxford English Dictionary at the word fully. Fully means completely or entirely to the fullest extent, which I think is an important point to make here. Anything other than all the cooperation obligations is not fully and not compatible with the words of the Security Council.
And your argument, I understand, would be that in the end, it appears that cooperate fully, in the sense you're interpreting it, in the sense of, according to the Rome Statute, in fact, it's a protection for Sudan than anything else. Otherwise, it may expose Sudan to arbitrary requests for which they may be bound to cooperate fully in relation to. Is that what you're saying?
Yeah, that's a way to conceive of it, right? Because again, we have two interpretations. Literally, cooperate fully means do anything the ICC says. And I think the more generous to Sudan interpretation is cooperate with the same benefits, exactly as you say, the same limits and exceptions that the states parties have given themselves. That's exactly correct. So in this chain of reasoning, I think there's only one step that's uncertain or arguable. The one step that I see as debatable is whether the immunity stripping provision of Article 27.2 has horizontal effect. Is that a cooperation obligation? And I agree it's open to argumentation. My group of scholars all would say yes for 5 reasons. Number one, the text. Again, the importance of text. The text, we think, indicates that it is for horizontal effect. Article 27 says it removes immunities under national law. It's already basic that you cannot plead domestic law before the ICC, so that word only makes sense if Article 27.2 is contemplating a surrender process. Number two, I think it clearly is a cooperation obligation, this removal of immunity, because it relates to the moving forward of a case. It removes an impediment to the court's exercise of jurisdiction over a particular case. Third reason, my impression is there's wide agreement here that Article 27.2 has horizontal effect among states parties, that if I'm asked to surrender the head of state of a state party, I don't need waiver because they're parties. And I would say the situation has to be analogous with states under the obligation to cooperate fully, because otherwise then it's not cooperate fully, it's less than fully. Fourth reason, I think the arresting state is certainly acting on behalf of the ICC. Klaus Kress yesterday invoked, or Monday maybe, invoked Antonio Casese's analogy of the giant with no arms and legs. Article 27.2, again turning to the text, talks about the exercise of jurisdiction by the court. If we can't get arrest, that prevents the exercise of jurisdiction by the court. And the fifth of these points is, there's been a lot of emphasis that Article 27 is in Part 3, not Part 9. And it's been suggested that's significant. So then my question is, did the drafters of the statute need to copy Article